Okay, so good morning, everybody, and welcome to our annual update. Today's the 27th of January, 2021, and this is our annual employment law update. I'm Chris Boyle, Head of Employment at Napthens, and it's good to see everyone today, albeit I can't actually see anyone at the moment other than my slides and my face on the slide. Let me start by setting out the agenda today for the update. So I'm going to do a brief introduction. We will then have a case update from Chris King and Roxanne Buckley, just looking back at some of the case law, as we always do with these events over the last 12 months, and then what to expect in 2021. Angela Barnes is then going to look at Brexit and the impact of that on immigration, and then Chris Walker will then come in at the end, last but not least, and look at health and safety developments, again, similar to what we did last year. We will take questions, but if people could put the questions in the chat box throughout, and then at the end we have a section there for 20-25 minutes, and we will take any questions, and I'll kind of put the questions to the speakers, depending upon the topic. So feel free to ask as we go along. So we've tried to focus in this annual update, as you'll see. So you can go back. We've tried to focus on in this update on other things other than COVID-19, but I guess I should mention COVID-19, bearing in mind the last 12 months that we've had. So it's odd to think that this time last year we were preparing to deliver this update from Stanley House outside Blackburn, Preston, and then we obviously did ones out on the docks in Liverpool and then up in Kendal. And I recall we focused some of our time in that update on holiday pay cases and things like the prospect of IR35 coming in, which of course it obviously didn't, but it is again. And I guess little did we know at that stage what was to happen and the impact it would have on all of us, but I guess particularly our employees, and kind of more importantly, I guess the role that HR would ultimately play in that, and the way things developed and changed overnight, effectively. And since then, as HR professionals and lawyers and people involved with people, we've had to deal with lots of different things, such as self-isolation rules, quarantine, changes to SSP, working from home, layoff, redundancies, risk assessments, furlough, flexible furlough, treasury directions, changes to terms and conditions, government guidance, times about 20, HMRC, Teams, Zoom, job support scheme, albeit that didn't come in, Skype, extremely vulnerable, CGRS, and so on and so on. All these words and concepts and changes and more changes that we've had to deal with, and changes and challenges that specifically HR teams and HR individuals have had to deal with. I think it's fair to say that COVID has created many challenges for us all, but especially HR teams, and especially people who have that responsibility for people within organisations. And of course, this isn't yet over and we have challenges to come, but I think we can say that the pandemic has undoubtedly shone a light on the strength of HR professionals and the importance of the people function in a business. HR teams have been able to show the true value and skill and their skill set through the creativity that we've seen and the agility and flexibility of their teams and the way that they've operate, and sometimes with a small bit of panic thrown in there for good measure. If we go back to the beginning of the pandemic, what we saw were HR teams seamlessly converting their workforce to work from home overnight, providing laptops, looking at digital infrastructure of the organisation to ensure that business could continue. And of course, many HR teams had to and still do provide details of critical communication and protocols in terms of what to do and what not to do and when to do things. And I think employee safety, possibly for the first time, became the prime concern, and a prime concern because of HR. I think despite the stress and the long hours that the challenges have been, I think what we can see is that we've shone a spotlight on the value of what HR has brought to organisations, if that in fact needed doing, in the way that we've kept or sought to keep employees engaged, motivated, safe, and productive throughout the last 12 months. And going forwards, I think it's fair to say HR will undoubtedly be responsible for looking to redefine, possibly permanently, the way that the workplace looks in the future. And I guess another way of looking at it is to say that COVID-19 has fundamentally emphasized or increased the emphasis on the human connection that HR provides, and that possibly only HR provides in an organization. And we touched last year's, on the update last year about mental health issues in the workplace. And I remember speaking to a few people at some of the seminars around the challenges that of the mental health posed at that point. And let's make no mistake about it, the next big challenge is the mental health one, and HR will play a major part in that going forwards. So the last 12 months has been a challenge for business, and of course there's going to be many to come. But HR professionals or people responsible for people within organizations have an awful lot to be proud of. And certainly one of the great things to see throughout the last 12 months has been the way that the HR profession and the HR community, led by various different people within organizations, has collaborated together and has worked together and has helped each other in a really positive way. So on that note, I'd like to thank all our clients, first of all, for the continued support and collaboration that they've given us, and we've helped with them over the last 12 months. It is always appreciated, the collaboration that we have with each other and throughout the team. And we hope that we have been there for you when you've needed us, and we'll continue to do what we can in the coming months to get our clients through these challenges that we face. So today is about looking ahead. It's also about looking back in terms of case law. I just wanted briefly just to update some of our clients on some of the news around the service that we are providing going forward. I wanted to do it now because I know we've got a lot of clients on the call, so I think it would be useful to do. So Charlotte, if you could just flip to the next slide. So I just wanted to explain that going forwards, we're going to introduce in our people portal. You may have seen some of this on social media, but we introduced this to our clients, and we're looking to do that in February. So in the next few weeks, our existing clients will receive this, and this will effectively replace the toolkit that you currently have. And the whole essence of the portal is to provide a one place where we can store all our knowledge and all our news, and allow you as organisations to store information as well. So if you go to the next slide, please, Charlotte. So you'll see when you go onto the portal that you will receive all the webinars, the Q&A sessions, the seminars that we do, all the things we're doing at the moment remotely, which we do record, will go on there, all the podcasts, and there'll be an Ask the Team box as well, and in order to send a message through to the team, which we'll then pick up. You'll also have access to our HR3 community Facebook page. If clients aren't already on that, then please let us know, and we'll be more than happy to send you the link for that. Next slide, please, Charlotte. You will also continue to get access to the toolkit. The big difference with this will be you will be able to access the toolkit that saved the documents to the portal. So I know that some organizations are saving things to other drives, maybe kind of Microsoft Word, that sort of thing. So you'll be able to now keep everything in one place in terms of documentation, and that will be GDPR compliant as well. So it will be secure. Next slide, Charlotte. The portal will allow you to also upload all your employee details if you wish, and save all your employee files against that as well. So again, allowing us to give the portal extra functionality, I guess, in terms of its usage going forwards. Next slide, please, Charlotte. And you will also be able to give employee a login as well. So employees will be able to log in to the portal and see their documents and see their information, update their information as well, which may be a useful tool as well. Next slide, please, Charlotte. It will also allow you to set tasks for perhaps other people in the HR team or other employees, and it will also allow employees to sign in and sign documents electronically as well, things like contracts of employment or handbooks. Next slide, please, Charlotte. And if a task or document is sent through to sign, they will receive an email, as you've probably seen in other software. Next slide, please, Charlotte. So that's kind of a brief summary of it. I just wanted to let everyone know, because we will be contacting clients in the next few weeks about this. So don't be surprised if you receive an email or a call saying we need information as to who needs to be on the portal. We will be starting with the basic module initially, which will just give access to the HR team, and then we'll kind of move on from there. And we've got other things planned with this portal that we've built going forward in terms of ER management and also tribunal claims as well, which we're just building a part of the module as well. Part of all this, sorry, just go back on the slide, Charlotte. Part of all this, and Chris Walker, our head of health and safety, will talk about this later on briefly. This also integrates with our health and safety management platform system as well. So effectively, if you're a client which has both health and safety and HR, you will be able to access both platforms from the same software as well. So I guess you've probably seen some of that as we've presented over the last few months around our health and safety service. So that's enough of me. I'm now going to hand over to Chris King, who's going to talk you through case updates. So over to you, Chris.
Thanks, Chris. I think you'll be fed up of how many Chris's there are after the end of this. Morning, everyone. I'm going to take you through some of the recent cases we've seen come through the Employment Appeals Tribunal, other appeal courts, and then I'll hand over to Roxanne, who's just going to finish off the case law update. So the first couple of cases I'm going to focus on are related to law on constructive unfair dismissal. So as a reminder, constructive unfair dismissal can arise when an employee resigns either with immediate effect or with notice, though it's rare in practice to resign with notice, in response to a fundamental repudiatory breach of the contract of employment by the employer. The fundamental repudiatory breach is more commonly called a last straw event and can be both a one-off event or a course of conduct which, when viewed together, amounts to a repudiatory breach of the implied term of trust and confidence. So in order to successfully claim constructive unfair dismissal, an employee can't have done something to affirm the contract after the breach, such as delaying in the resignation after the act, or latest in a series of acts, which they say amounts to a fundamental breach. So employers should be conscious, however, that should the conduct complained of by the employee continue after the employee has arguably affirmed the employment contract, it can resurrect a right to claim constructive unfair dismissal. So in that context, we can have a look at the first case. So this is an Employment Appeals Tribunal case called Williams and Alderman Davis Church in Wales Primary School. And the EAT asked the following question in this case: if a final straw is entirely innocuous, does that mean all previous conduct by an employer is irrelevant? The earlier decision at the Employment Tribunal from which this was appealed considered that the last act by the employer in this case, which was just an instruction by the employer to another employee not to speak to the claimant pending the outcome of an investigation and disciplinary process, was not in and of itself a fundamental breach of the claimant's contract of employment, and in fact was a reasonable approach to take. This was despite the fact that there'd been significant failings by the employer previously in the way that they'd handled the investigation, which included extensive delays in carrying out the investigation, causing the employee to be absent due to severe stress and anxiety, and the employer also prevented the employee having access to information for the purposes of challenging the disciplinary process. The employee had not affirmed these previous breaches by the employer, but because the employee had resigned in relation to him not being able to speak to another employee, and the tribunal considered that to be entirely innocuous and not a fundamental breach, they determined that the claimant couldn't claim constructive unfair dismissal. When this got appealed to the EAT said this approach was incorrect. So in answering the question, the EAT said, so long as there has been conduct which amounts to a fundamental breach, the breach has not been affirmed, and the employee does resign at least in part in response to it, constructive dismissal is made out. That is so even if more recent conduct has also contributed to the decision to resign. So the key point, therefore, when considering if a course of conduct by an employer amounts to a fundamental breach, is to look at the whole course of conduct, even if the tipping point or last straw is not in and of itself capable of amounting to a fundamental breach. If we move on to the next slide. So this is the case of Phoenix Academy Trust in Kilroy. I'll go into the facts a little because it's relevant to this particular case. Phoenix dismissed Mr. Kilroy summarily and just prior to receiving his resignation letter alleging constructive unfair dismissal. Shortly afterwards, Mr. Kilroy invoked Phoenix's contractual appeal procedure. Before the appeal hearing, however, Mr. Kilroy's solicitors wrote to Phoenix saying, irrespective of the result of the current appeal, there is no question of our client returning to his current employment. After that letter, but before the appeal hearing, Mr. Kilroy brought an unfair dismissal claim against Phoenix based on the original summary dismissal. Phoenix upheld Mr. Kilroy's appeal and reinstated him with a final written warning. However, Mr. Kilroy then resigned by a further letter alleging constructive unfair dismissal. As part of its defence to the unfair dismissal claim, Phoenix argued Mr. Kilroy had affirmed the employment contract by appealing the original summary dismissal. The tribunal at the first decision upheld Mr. Kilroy's unfair dismissal claim and agreed that he'd not affirmed the employment contract by appealing. They relied on the statement he made in his letter outlining his intention not to return regardless of the appeal decision, so Phoenix appealed that decision to the EAT. The EAT considered that Mr. Kilroy had in fact affirmed his employment contract by appealing. The effect of Phoenix's decision to overturn the dismissal on appeal was to revive the employment contract, and the dismissal therefore vanished and could not be relied on as the basis of an unfair dismissal claim. However, the EAT did find that the tribunal had failed to properly consider whether Mr. Kilroy had in fact been constructively unfairly dismissed by Phoenix following the internal appeal outcome. So in relation to the question on the slide, then where an employee appeals against the employer's original decision to dismiss and that appeal is successful, it has the effect of negating the decision to dismiss, reviving the employment contract and allowing it to continue uninterrupted, and it's often referred to as a vanishing dismissal. In these circumstances, as there is no dismissal, the employee cannot pursue an ordinary unfair dismissal claim. Note, though, that it doesn't necessarily prevent them from alleging constructive unfair dismissal, as in this case. So if we move on to the next slide. So this case is about ordinary unfair dismissal, specifically procedural unfairness. So in this case, the claimant was a senior manager in the employer's business. A relationship with the line manager deteriorated at a critical point for the employer. The line manager decided to dismiss the claimant at an appraisal meeting, having not forewarned the claimant, gone through any formal process, or provided the right of appeal. The tribunal at first instance found that the decision to dismiss without procedure was within the bands of reasonable responses and justified this, saying that the procedure would in fact have made things worse. And the EAT, on the face of it, quite surprisingly, declined to overturn the tribunal's decision. The EAT considered that process for the sake of process would be futile in this case, and in very exceptional circumstances, not following any process at all could be within the band of reasonable responses. The EAT did stress caution on behalf of employers, however, stating that dismissals without following any procedure will always be subject to extra caution on the part of the tribunal before being considered to fall within the band of reasonable responses. So in simplest terms, it would be very, very exceptional circumstances indeed which would justify dismissal without following any process. So on to the next case. This involved a claimant who was a teacher who had been charged with having indecent images on his computer, but as it was not possible to determine who accessed those images, he was not prosecuted. But the procurator fiscal reserved the right to prosecute in the future. The employer sought the evidence from the police but wasn't provided with it, and the employer did, however, decide to proceed with disciplinary action in spite of this, on the basis that the claimant was involved in an investigation, but importantly, not expressly basing the disciplinary action and allegations on potential reputational damage to the employer. The claimant denied responsibility for the images, and the disciplinary officer did not uphold that he downloaded them, but he did dismiss because he found there had been an irretrievable breakdown in trust and confidence, because it couldn't be shown that he hadn't downloaded the images, and therefore the potential future prosecution could risk reputational damage. The tribunal at first instance found on behalf of the employer that the claimant had been fairly dismissed, and the claimant appealed that decision. And the EAT said that the dismissal was actually unfair on two grounds. The first, that reputational damage was never an allegation put to the claimant in the disciplinary process, and he therefore did not get the opportunity to challenge it. And secondly, the unknown risk cannot be relied upon to tip the scales of a disciplinary officer into being more sure than not that allegations were founded. The disciplining officer relied both on a potential future conviction and potential reputational damage should that future conviction occur to make their decision to dismiss. And both of these were completely unknown at the time that decision was made. This case demonstrates the need to ensure that a disciplinary invite letter lists all allegations clearly, and any decision is based only on those allegations that the employee has had notice of. Similarly, the balancing exercise to determine whether an employee has or has not committed the misconduct should be based on the evidence and representations made and not on speculation. Moving on to the next case. This case involved the use of a competitive interview process during a redundancy consultation, and it gives good guidance on when that will be an appropriate method of selection. This was appealed by the employer, Gwynedd Council, against findings of unfair dismissal by the tribunal in first instance. So Gwynedd dismissed as redundant a number of teachers following a reorganisation. As part of that process, instead of using a scoring matrix, Gwynedd chose instead to use a competitive interview process as their selection method. The important point of note in this case was that all the teachers were expected to apply for their own roles, not a different role that had been put into the new structure. So the EAT agreed with the tribunal that the dismissals were unfair. The fact that the teachers were effectively applying for their own jobs, plus the fact that there was no consultation over the proposals and no appeal against dismissal, rendered the dismissals unfair. The EAT did give some helpful guidance, however, when a competitive interview process could be a fair method of selection. The EAT said that a forward-looking process, such as a competitive interview for a new post, and a process of consultation and selection could render any dismissals fair. This case highlights that competitive interviews can be used by employers, but employers should not be asked to apply for their old jobs, and there should be a process of consultation about the proposed method of selection and a justification by the employer about why they believe that's the fairest process. If we move on to the next case. So this is a TUPE case. It's a very interesting case. It's a Court of Justice of the European Union case, and it could have large implications for those businesses who do a lot of business and asset purchases and trigger TUPE. So this is the current position, but we will see whether the implications get watered down following Brexit. So the CGAU decided that where there was a business transfer to multiple transferees, an employee who is assigned to that undertaking to transfer can in fact have their employment transferred to each of those transferees in proportion to the task performed by that employee. So in simple terms, that means an employee can go to from having one employer to multiple employers, so long as the effect of the transfer doesn't worsen their working conditions or otherwise affect their rights. Even more concerning is that if the division of the contract is not possible, or it's technically possible, but it would adversely affect the individual's rights, which in my view is going to be the majority of cases because it sounds like a nightmare, then it doesn't stop the transfer to the transferees happening, and the transferees will be liable for any termination of employment, even if that is initiated by the employee. This shouldn't affect service provision changes, but if you are involved in a business transfer as a transferee and you're aware that there are potentially multiple transferees, this case needs to be a forefront of your mind at the moment until we see any further clarification about whether that's going to carry on. So moving on to another TUPE case. This case involves changes to terms and conditions of employment following a TUPE transfer. So TUPE provides that any purported variation of the employment contract of a transferring employee is void if the sole or principal reason for the change is the transfer itself, or because of a transfer-related reason that's not an economic, technical, or organisational reason entailing a change in the workforce. This case involved four rather naughty directors who worked for a company called Lancer and who were due to transfer to Austria. Just prior to the transfer, they decided to amend their employment contracts to include much more favourable terms, including a guaranteed annual bonus of half of their salary, longer notice periods, and a guaranteed termination payment. They did all of this knowing that Austria would be picking up the bill. The directors transferred and eventually were dismissed for gross misconduct, and then they brought claims of unfair dismissal off the back of those. And their claims also involved claims for the termination payments that they themselves had introduced. The tribunal at first instance found that the variations the directors were put in place were void under TUPE, and also the EU's abuse of law principle. So the directors appealed, but the EAT agreed with the tribunal and confirmed that TUPE makes no distinction between negative variations and positive variations. All variations that are as a result of the transfer are void under TUPE. Practically, an employee subject to a transfer who has a positive change proposed to them as part of the transferee's measures is not going to challenge these as void under TUPE, but the technical position is that they are. So the next slide is my last case, and this is one that you may be familiar with because it's been in the media quite a lot. And there's been a lot of media attention because it's a group claim, a group action brought by a number of Morrisons staff against Morrisons. The background to this involves a disgruntled employee who was an internal auditor. Instead of sending payroll data to Morrisons auditors, he uploaded it onto the internet, which caused a massive data breach. This claim was appealed all the way up to the Supreme Court, as the High Court and the Court of Appeal both found Morrisons vicariously liable for a breach of statutory duty, misuse of private information, and a breach of confidence. The Supreme Court upheld Morrisons' appeal, overturning the decision of the lower courts. They said that it was not enough to establish that an employer should be vicariously liable for the actions of an employee just because those actions arose from a task closely related to what he was tasked to do. An employer will be vicariously liable if the employee is engaged in an act, however misguidedly, for the purpose of furthering the employer's business. Where the act is one of personal vengeance or in pursuit of private ends, the employee is not acting on the employer's business. So I'll hand you over to Oksana now, and she's going to take you through the final few cases of the case law update. Thanks very much.
You can move on to the next slide. We'll just go straight into the next case. Okay, so Employment Appeal Tribunal case, Duchy Farm Kennels and Steels, which concerned a breach of confidentiality provisions in a COT3 agreement. So key question here is, can a breach of confidentiality by one party, usually the employee, release the other party from their obligations to make any further payments of agreed instalments of a settlement sum? So the background to this particular case, Mr. Steels brought a number of claims against his former employer, including a claim for unfair dismissal. A settlement was reached by way of a COT3 agreement with the assistance of ACAS, and it was signed by both parties' representatives. And the terms of the COT3 provided that Duchy Farm Kennels would pay a settlement sum of £15,500 by way of 47 weekly instalments to the claimant. It also included a warranty that Mr. Steels had not disclosed the facts and terms of the agreement and he'd keep it all confidential. So within a few weeks of receiving a few dollars in his back pocket, what did he go and do? He sang like a canary and disclosed the facts of the agreement to an ex-employee. By this point, he had been paid about just under £3,000. So the relevant section 19A of the Employment Tribunals Act provides for the recovery of sums payable under a settlement where ACAS has affected the agreement. So that gives a cause of action there for Mr. Steels, unless a declaration is sought by the paying party that that sum would not be recoverable under the general law of contract and that declaration is granted by the court. So obviously Mr. Steels, his payments were curtailed. He then applied to the court for the remainder of the sums due under the settlement agreement, and Duchy Farm Kennels then counteracted by seeking a declaration that owing to the breach of confidentiality provision of the agreement that no further sums were recoverable by him. So in the county court, Mr. Steels denied breaching the confidentiality clause and stated that even if he had, a bit strange to say that if you hadn't done it, but even if he had, the confidentiality clause itself was not a condition of the COT3 and that his disclosure would not amount to repudiatory breach of such agreement. On assessing it, it was found that he had breached the confidentiality provisions, but that this did not amount to a repudiatory breach, which would have allowed an innocent party to terminate the contract depending on the circumstances and the nature of the breach itself. And in addition, the confidentiality clause was not a condition of the agreement, where any breach of a condition would entitle an innocent party to bring the contract to an end, which is what Duchy Farms were hoping to rely on. Therefore, the obligation, unfortunately, for them to continue paying these weekly instalments to Mr. Steels continued. So on appeal to the Employment Appeal Tribunal, it did agree with this decision, and they stated that confidentiality provisions was not a condition. So I think a key point to take away from this is that, you know, parties to a contract should state expressly whether a term is a condition or not, and that any breach of it will absolve the innocent party from any further duty to comply with its obligations under the contract. Or separately, you could agree that in the event of any breach, the ex-employee must repay all or a proportion of the money which has already been paid to them under the agreement. Okay, next slide, please. Okay, so another Employment Appeal Tribunal case, Kelly against PGA, E. Kelly against PGA European Tour. So this regarded remedies of re-engagement. So in this particular case, the claimant had a substantial amount of service. He was dismissed after 26 years of service with this employer. And on the back of that, he brought claims of unfair dismissal, wrongful dismissal, and age discrimination. So in the Employment Tribunal proceedings, the employer actually conceded that the claimant had been unfairly dismissed and held their hands up about that. And that was due to a lack of a fair procedure which had been taken in dismissing the claimant. However, because of the proceedings itself, they discovered that the claimant had actually made some covert recordings of the meetings which they were unaware of at the time. So on the remedy hearing then, the claimant had stated that he wanted to go back to the employer. Now, where a claimant actually states that, the tribunal is obliged to consider it. So the first thing that they'll consider is whether, you know, he can be reinstated to his role, and if it's not appropriate to reinstate, they'll then consider re-engagement. So reinstatement itself is where the employer is to treat the employee in all respects as if they'd never actually been dismissed in the first place. So you are re-employing them on the same terms and conditions. There's no loss of pay. They get the same pension rights, and, you know, they're entitled to any pay increases which would have happened during the course of that time as well. And his continuity of employment is preserved. If that's not appropriate, they then consider re-engagement, where the claimant must be engaged in employment that is comparable to the job from which he was actually dismissed, or in other suitable employment. So in this particular case, the majority in the Employment Tribunal did not find that the lack of trust and confidence arising from the claimant's capability and integrity as a result of making those covert recordings were so significant to make it impractical to order re-engagement. So they obviously thought reinstatement wasn't appropriate. They did consider re-engagement, and the Employment Tribunal actually made an order for re-engagement for him. And I think it was a role as a director in another location in China. On appeal, the employer went to appeal, and they were actually successful in showing that it genuinely and rationally concluded that it lacked trust and confidence in the claimant's capability. And in addition to that, the CEO in the company had actually lost trust in him due to the covert recordings, a number of meetings prior to dismissal. So I think a key point of this one is that all evidence at the time of the remedy hearing is actually taken into account in deciding the appropriate award to make, including re-engagement, and that also includes any actions which have been discovered after dismissal. Okay, the next slide, please. Okay, so again, Employment Appeal Tribunal case, Sullivan and Berry Street Capital Limited. Oh, can you hear me? Yeah. Sullivan and Berry Street Capital Limited. So the claimant suffered from paranoid delusions in or around May of 2013 following a relationship breakdown at that time. And he actually believed, and he genuinely believed, that he was being stalked by a Russian gang and that this affected his timekeeping and attendance at work. So there was regular reviews which were conducted with the claimant between July 2014 and September 2017. And it didn't actually highlight any continuing belief on behalf of the claimant that he was being stalked. His financial performance at work was good, although there were still intermittent and continuing issues with his timekeeping and attendance. There are a few instances in 2017 where he seemed to have some of these delusions again about being stalked by a Russian gang. The claimant informed that he would be absent from work for around 4 weeks in or around September of 2017 on the advice of a doctor. Now, the employer, completely exasperated with him at this point, decided, after receiving that information that he was going to be away for work for 4 weeks, decided to terminate his employment on the grounds of capability and his attitude. And subsequent to that, the claimant then brought a claim for unfair dismissal and disability discrimination. So, definition of disability then, it's contained under Section 6 of the Equality Act, which states the person has a disability if he has a physical or mental impairment, and the impairment has a substantial long-term adverse effect on his ability to carry out normal day-to-day activities. The Employment Tribunal held that the claimant did not have a disability within the meaning of Section 6 of the Equality Act. They held that the substantial effect on the claimant's ability to carry out normal day-to-day activities did not continue beyond September 2013, as he seemed to be performing quite well at work in that period beyond that. In considering what substantial means for the definition of disability, it is more than minor or trivial, and an effect of an impairment is classed as long-term if it has lasted for at least 12 months, it's likely to last for at least 12 months, or it's likely to last for the rest of the life of the person affected. Importantly, in considering this case, if an impairment ceases to have a substantial adverse effect on a person's ability to carry out normal day-to-day activities, it is to be treated as continuing to have that effect if that effect is likely to recur. And this is assessed at the time of the alleged contravention. So when this actually went to the EAT, likely to recur, as established in prior case law, was taken to mean could well happen. So it's quite a low threshold. And the EAT found in this case that despite the delusions or the effect appearing to reoccur in 2017, it did not follow that at the time in 2013, the substantial adverse effect of such impairment was likely to recur, and therefore his claim for disability discrimination failed. Okay, next slide. Okay, so this one, Heskett and Secretary of State for Justice, so it's a Court of Appeal case, and it concerns indirect age discrimination. So Mr. Heskett here was employed in the public sector as a probation officer. The Ministry of Justice changed its pay structure in 2010 to meet a cap on increases in the public sector, and pay increases subsequently were then limited to 1% of overall pay costs. So I think it's quite similar in terms of, say, teacher salaries and things. They have like a pay scale and they go up in spine and increments and things. So they'd actually had to put a cap on that at that particular time. So as a result of that cap, it meant that progression up a pay scale took much longer. So in 2016, at age 38, he brought a claim of indirect age discrimination on the basis that the rate of the pay progression for his job had drastically reduced, and this disadvantaged younger employees since they were inherently less likely than older colleagues to have reached the top of any applicable pay range when this policy came into force. The PCP advanced by the claimant was the implementation of the pay policy as operated by the respondent from 2011, and such policy including the pay progression based on length of service. Justification advanced by the respondent was that there was a significant reduction in public funds which were available, and in light of the significant downturn in the economic climate from 2010, they had to put these measures in place. Mr. Heskett advanced principles, I think which were contained in another case known as Woodcock and Cumbria Primary Care Trust, that the saving of costs alone could not amount to a legitimate aim in defending this claim of indirect age discrimination. Mr. Heskett's claim was dismissed in both the Employment Tribunal and the Employment Appeal Tribunal. And they found that the respondent, like any private sector business, needed to live within its means, and the measures of it adopted were a mechanism to do so. It wasn't the sole objective. They did not find that the respondent was relying on costs alone to justify discriminatory conduct. And in any event, the tribunals found that the implementation of the pay policy was a short-term means in response to the economic pressures that it was facing. So he wasn't happy with that. He went to the Court of Appeal, where a term known as the cost plus principle was discussed, which is costs alone, so either the saving of costs or the avoidance of such, cannot justify indirectly discriminatory treatment. And the financial burden of acting in a manner which does not discriminate can only be relied on as an element in a justification which involves other factors. So on the basis of that, his appeal was actually rejected. They didn't find that it was just cost alone which had come into play, but there were other factors in this particular case as to why they took the measures which they did. So I think a key point of this case is that if an employer is subject to financial constraints which oblige it to reduce its costs, for example, I don't know, redundancy exercises and things like that, then that can be enough to amount to a legitimate aim. Next slide, please. Okay, so what to expect in 2021? That's if we can predict this far. I remember having the same old sort of New Year's resolution in 2020, like new me, yay, and then 2020 happened. So I kept very quiet this year. So 1st of April 2021, national minimum wage. The rates to apply from the 1st of April, we're currently awaiting details of what this will look like, although it's not expected to be a big increase as previous years because of the pandemic and the constraints of that. The national living wage, the age of entitlement under the highest rate category is due to reduce from 25 years to 23 years of age from the 1st of April 2021. So key point for you, just be ready to comply with these changes, get your books in order, look out for any further announcements from the government in respect of this. On the 6th of April 2021, the IR35 off payroll rules for the private sector are due to take effect. This is following on from them actually being postponed from last year as a result of the government dealing with the COVID-19 pandemic. The rules here shift the burden of tax reporting from personal service companies to the end client. So by this, treating the company as the employer for income tax and national insurance contribution purposes. On the 30th of April as well, it is anticipated that the coronavirus job retention scheme will be ending as well. So just another date for your diary. Next slide, please. Okay, so key cases then to be decided. So this first one, Court of Appeal case, so are on the application of the Independent Workers' Union of Great Britain against the Central Arbitration Committee and others. So background on this one, just a note for yourself. So a trade union can apply to be recognised by an employer to conduct collective bargaining in respect of a group of workers. Such bargaining can cover the core areas of pay, hours and holidays. Article 11 of the European Convention of Human Rights states that everyone has the right to freedom of peaceful assembly and to freedom of association with others, including the right to form and join trade unions for the protection of his interests. In this particular case, the Independent Workers' Union of Great Britain represented some outsourced, I think it was security staff, working for Cordant Security Limited at various University of London sites. There was already an existing agreement between the union Unison and Cordant and a separate agreement between Unison and the university respectively. So the Independent Workers' Union of Great Britain argued that Article 11 should extend to bargaining with the entity that effectively controls terms and conditions under which those outsourced workers work. However, the Central Arbitration Committee refused this application by the trade union to be recognised for collective bargaining purposes in respect of those outsourced workers, ruling that the absence of any contract between those outsourced workers and the university directly was fatal to their application, as the university was not the employer of such workers. I think this particular decision is reflective as well of sort of their reasoning, I think from cases like Deliveroo, where they say that Article 11, it doesn't actually extend its right outside of an employment relationship, so just something to bear in mind. A key point from this case, so if an end user could be fixed with employer status under the law, it would fundamentally alter the nature of outsourcing and undermine one of its main commercial benefits, so a little bit of a win there for employers. Okay, so the next slide, please. Okay, so the Supreme Court case then of Harper Trust and Brazil, you may have heard of this case through previous updates regarding holiday pay. So another case which is coming through the tribunals. So the key question here is whether holiday entitlement of part-year workers on permanent contracts should be prorated to that of full-year workers to reflect the fact that they don't actually work throughout the full year. So there is five, as you know, under national law, under the working time regulations, we are entitled to 5.6 weeks of holiday entitlement, and this entitlement is to be paid at the rate of a week's pay for each week of leave taken. So the correct reference period, so as of April of last year now, in calculating holidays for those with irregular working hours has now shifted from 12 weeks to 52 weeks, excluding any weeks which no pay is actually made. The 12.07% calculation rate is often used for those with irregular working hours, and it's based upon a standard working year of 46.4 weeks. Obviously, you get the full 52 weeks minus your national entitlement of 5.6 weeks, with 12.07% being the 5.6 of the 46.4 weeks. A little bit of maths there for you. Anyway, Mrs. Brazel was a part-time music teacher employed under a permanent 0 hours contract. She mainly worked term time and was required to take annual leave during the school holidays, and the holidays were calculated at 12.07%. She brought a claim for unlawful deduction and less favourable treatment on the grounds of a part-time status, on the basis that that 12.07% calculation did not reflect the calculation method outlined under Section 224 of the Employment Rights Act, and that is to be paid based on average earnings over, at that time, a 12-week reference period immediately before the holiday was taken. So effectively, the calculation under Section 224 would mean that Mrs. Brazel would receive a higher percentage of her earnings as holiday, as she worked for less than 32 weeks in the year, and the 12.07% calculation is based on a working weeks of 46.4 weeks throughout the year. The Employment Tribunal stated that a principle of prorating should apply, and the law should be read down for part-time workers who work fewer than the 46.4 weeks, so that any pay, holiday pay, is capped at 12.07% of the annualised hours that they actually work. On appeal to the Employment Appeal Tribunal, they found that actually the Employment Tribunal was wrong in capping the holiday to 12.07% of annualised hours. They found no requirement in the working time regulations to prorate holiday for part-time employees, and no similar provision in law to prevent less favourable treatment of full-time workers. Usually the law is set up for fixed-time workers, part-time workers, those protections. The Court of Appeal, there was a discussion that under the Working Time Directives, the EU law, that workers accrue annual leave in proportion to the time that they work, but member states are free to adopt arrangements which are more favourable, which is what we have here in the UK. So on review of the working time regulations, there is no provision for prorating, and as such, there's no requirement to prorate the leave entitlement of part-time workers to that of full-time workers. So key thing from this, although the principle only applies to holiday entitlement and pay for those on permanent contracts, given the widespread reporting of this judgment and pretty much holiday pay cases which are coming through the tribunals, it's likely that it will lead to a further flood of part-year employees raising the issue of their holiday pay and potentially bringing those claims. Next slide. I think this is the last one from me. So ongoing government consultations then. So the first one, the government is to report on its review of employment rights for survivors of domestic abuse. So as more and more workers at home more than ever due to lockdown restrictions and dealing with the current COVID pandemic, unfortunately this has negatively impacted victims of such abuse, where spending time away from their abuser and attending work can offer some degree of independence. The government is alive to the issues as reflected in the current domestic abuse bill, which has had its second reading in the House of Lords this month. Separate to the bill, Business Minister Paul Scully launched a review on supporting workplace for survivors of domestic abuse. And this includes views from employers on flexible working, unplanned leave, paying wages to a different bank account, or making emergency salary payments. So you can see how the government there are trying to put things in place to support domestic abuse survivors. A joint consultation on proposals to reduce ill health related job loss. So on the 7th of October 2019, the joint consultation was actually closed, and we are still awaiting government response to this and its outcome. So as soon as we receive it, I'm sure there will be a bulletin being circulated. A full government response to the Law Commission report on employment law hearing structures expected. So the employment law hearing structures report has been published by the Law Commission, and they reviewed the jurisdiction of employment tribunals and all areas where they share jurisdiction with the civil courts to hear employment and discrimination claims. So it found that there was a range of issues, including unsatisfactory gaps in employment tribunals' powers, which can often mean that claimants have to bring two different sets of proceedings because the tribunal can't deal with all of their claims. So as a result of this report, there's been a number of recommendations made, 23 in total, which include, I won't list them all, they include increasing the powers of the employment tribunal to decide breach of contract claims whilst the individual remains in employment. At the moment, their employment has to have ended. Also increasing the limit to bring the claim to 6 months to the limitation period, and also increasing the limit to damages for breach of contract to 100,000. So it's probably just one of those to keep your eye out on, but as usual, we will circulate any updates in due course. That's it from me.
Morning, everyone. We're going to spend the next 15 or 20 minutes looking at the position with Brexit. So if we could move on from my delightful photograph, please. Thank you. And the good news is that after a very long time of talking about Brexit, I hope that this is the last time that it appears as a topic on the annual update, because it's now been 4.5 years since the decision was made to leave the EU, and at long last, the UK has now left the EU. And whatever your view on Brexit, the impact, particularly on my area of work, which as well as being an employment specialist, I focus on immigration, the impact on immigration, on employing EU workers in particular, should not be underestimated. And I'm regularly speaking to clients from a range of different sectors who are feeling the repercussions of that decision quite significantly. So just to recap very quickly on where we are in terms of the Brexit timetable, as I said, decision was made to leave the European Union way back in June 2016, would you believe? It seems a very long time ago now. And fast forward a number of years, we then entered the transition period almost a year ago now. And for our purposes in terms of immigration, free movement continued throughout that transition period. So that's from the end of January until 31st of December 2020. So nothing changed during that period in terms of employing EU workers. And that was so that the government could really have some breathing space to try and keep the status quo whilst they agreed the trade deal, which we now have. And for anyone who's feeling a bit bored during lockdown, you're very welcome to go and read the 1,450 pages of the trade deal at your leisure. But as I say, getting that trade deal done now means that free movement has ended, as it was scheduled to do so at 11 o'clock on the 31st of December 2020. We're going to have a closer look in the next few slides in terms of what that means for your workforce. And as I've said, there is a significant impact, especially in sectors like care sector, hospitality, agriculture. I'm seeing a lot of queries coming in from that sector, but also construction, manufacturing. And that's because there has been such a heavy reliance on that EU workforce. And quite frankly, companies are wondering how they're going to get the supply of labour to do the jobs that they have to do there. If we could please move to the next slide. Okay, so as I said, looking at what Brexit means for your workforce, free movement has now ended for EU, EEA and Swiss nationals in the UK, and that was 11 o'clock on the 31st of December 2020. We now have the new points-based system, which I'm sure you'll have read about in the news or seen in the news, and that applies for those people entering after the 31st of December, so basically from the 1st of January 2021 onwards. And the most crucial point to note on that new system is that it now treats all of non-UK citizens the same. So whether they're European citizens or they're non-European citizens, it's equal treatment for them under the new system if they then want to come into the UK. So where does that leave EU workers? And that's the final bullet point on the page. The preference is that they can apply for the EU settlement scheme if they are eligible. So if they came here before the 31st of December, and we're going to look more closely at the EU settlement scheme. But if they are not eligible for that scheme, then as employers, you may want to be looking at the possibility of employing EU workers under the new points-based system. And that's definitely the trickier of the two options. By far the EU settlement scheme is an easier process for your EU workers if it's possible. Okay, so let's have a closer look at the EU settlement scheme. If we could just move the slides along, please. Okay, so just to summarise what the EU settlement scheme is and why it's there, it's basically a way that EU nationals can secure their status in the UK so that they can formalise or legitimise, if you like, their right to be here. In terms of eligibility, who is eligible, as I've said there, EU nationals and family members who first entered the UK before 11 PM on the 31st of December 2020. So it's crucial that they were in the UK before that date. And they will then be granted either settled or pre-settled status under the settlement scheme. Now, crucially, in terms of deadlines, they have until the 30th of June to apply, so 30th of June 2021 to apply for the EU settlement scheme. But as I say, they still need to have been here before the 31st or on the 31st of December 2020. So in terms of whether they would get settled or pre-settled status, that depends on how long they have been continuously resident in the UK. If they've been continuously resident for more than 5 years, they would be granted settled status. If it's less than 5 years, they would be granted pre-settled status. And when we're talking about continuous residency, the test for that is that they cannot have been absent for more than 6 months in a 12-month period. So absent from the UK for more than 6 months in a 12-month period. There are certain limited exceptions to that rule, but that's the general eligibility requirement. So what does that mean for you as an employer in terms of people who have or have not applied for the EU settlement scheme? Firstly, to say there's no difference in terms of their right to work in whether they've got settled or pre-settled status. As long as they've got one of those two rights, then they can live here, they can work here, they can access benefits, NHS, pensions, as any UK citizen would. If they are granted pre-settled status, they can then go on to apply for settled status once they meet that continuous residency requirement, and then in turn, if they want, they can apply for British citizenship thereafter. So it is a route to settlement for those individuals. Now, crucially, and again, I'm going to touch on this later when we look in particular at right to work checks at the moment, but these individuals do not need to show you that they have applied for or successfully achieved status under the EU settlement scheme. And very importantly, you should not be pressing or pushing to receive that document, because then you run the risk of a race discrimination claim. So by all means, if somebody invites that information or volunteers that information, you can put a copy on their file, but you shouldn't be making that a requirement in terms of your right to work checks. And the second bullet point there, so what about those people who entered for the first time after 11 o'clock on the 31st of December 2020? So basically those people who are not eligible for the EU settlement scheme. And if we could just move the slides along, please. And just to park this table for 1 minute, I'm just going to set out the new system to you now, just so that you've got an understanding as to how it works, and then we'll move on to look at the details of the table. So we've got this new points-based system, and it is a points-based system. As you can see, the individual from that table has to reach a certain number of points in order to come into the UK under this new system. Now, it was branded very much a new revolutionary system. It was referred to as the Australian points-based system, and you know, it was very much with the purpose of reducing net migration into the UK. Actually, it's not that revolutionary and not that different to the system that we had in place for non-EU workers for the past however many years, that we've had that system in place. So it's very similar to the system we've already got. But as I said earlier, the big difference is it applies to EU workers as well as non-EU workers now. So anyone you want to hire from outside of the UK will need permission under this new system, and that's the crucial difference. Now, for those of you who don't know, it's a 5-tier system. You may have seen this on the news. I'm not going to go through the various tiers. We simply haven't got time for that today. But the most important tier, the one where as an employer you may wish to bring EU and non-EU workers into the country, is what was tier 2. It's now called the skilled worker visa. And as I've said, the individual has to score sufficient points under that system in order to enter the country, but also as an employer, you need to be a sponsor for that individual. And in order to sponsor the individual, you need a sponsor license. And again, we're going to look at what that would involve in due course. So just to very quickly look at the table, and again, it's complicated. I'm not going to go into the details details of it. But if an individual wanted to come into the UK as a skilled worker, they'd need to get 70 points. They need to score 70 points in order to come in. Now, some of the points are mandatory, some are tradable. So for example, and this is a big change, it's a mandatory requirement that that individual has to have a certain level of English language for which they would then score 10 points. So EU workers previously could come into the UK to work even if they couldn't speak a word of English. That's very different now under the new system. So that's the mandatory area, and also things like skill level, that's a mandatory requirement. So for example, the role has to be at least A-level equivalent. Now again, you know, lots of clients are finding this challenging because this route is not going to help, for example, my agriculture clients who need people to come and pick apples. It's not going to help my clients in the Lake District who need people to serve on tables, because those roles are not at A-level equivalent, and also they're not at a sufficiently high salary to score sufficient points under this category. And in terms of salary, there is an element of trading there, and that's where this new system does differ from the old one. That was very fixed, and it was a certain set salary level. With the new model, yes, you can trade points for different salary levels. Generally, they have to be receiving in terms of salary 25,600, or what's called the going rate for that particular job. But if, for example, the job is on a shortage occupation list, so we've got a real shortage of people doing that role in the country, or the individual has a PhD that is relevant to the job that they're going to be doing, in those particular circumstances, we can pay at a lower rate. But as I've said, you know, I don't want to give any false illusion. This new system is aimed at the medium and higher skilled workers who are coming into the country. It is not going to help with what would be termed the lower skilled, the lower paid, the pickers, the packers, the people working in the factories. And that's where the challenges really lie for clients that I'm speaking to, as to where we go from there. Okay, so as I've said, if you want to use this new system for the medium and highly skilled workers, you as an employer will need a sponsor license. So if we could just move to the next slide, I'll talk you through how you would go about getting a sponsor license to employ skilled workers. The first thing I've said there is don't delay, and that's been my consistent message right since the points-based system was first introduced, because I think we've come accustomed to how easy it is to employ EU workers. You know, it's as easy as it is to employ a UK worker. That's all changed. So if you now want to employ EU workers, you're going to have to get a sponsor license. It's an online application, and there's going to be a period of delay. Sponsor licenses themselves can take around 8 weeks to be processed by the border agency. There is a priority service where the employer will pay an extra £500 for the service. I used this just before Christmas. It worked very well. We got a decision in a few days, and they do say that you will get a decision within 10 working days. It works very well whilst it's working very well. But if the border agency become inundated with requests for sponsor licenses, I'm not sure that they've got the numbers of people there, the caseworkers, to process. And at any point, obviously, that priority service could be pulled. So just bear in mind, it's a time-consuming process. What some clients are doing is, although they don't need a sponsor license right now, so there's not an immediate need to employ EU and non-EU workers, they are getting a sponsor license in place because it lasts for 4 years, and they know that within a 4-year period, they are very likely to need to rely on employees to come in from other countries rather than just the settled workforce. As I've said, it's an online application and you need to submit supporting documents. Now, I make that sound very simple in a bullet point. Don't underestimate how onerous it is to complete that online application and submit the supporting documents. It's not just a 30-minute online application form. And the supporting documents, again, it's a very strict deadline. You've got 5 working days to submit those supporting documents once the online form has been submitted. And I've had clients in the past frantically searching around for the relevant supporting documents. Make sure if you're going to submit your online application, you've got your supporting documents there ready to submit, ideally that same day, so that it's done and it's sorted. As is often the case with any process like this, there is a cost involved, and the cost is set out there. The 536 is if you're classed as a small employer, the 1476 is if you're a large employer, so they do break it down in terms of the size of your organisation. But, you know, as I said, it's an additional cost, and again, you know, sponsor licences generally in terms of cost in terms of management time, but also cost of application fees, mean that it's definitely going to be more expensive to employ EU workers than it has been previously. And probably the main point to focus on this slide is the next one, where I said you need the HR processes in place in order to manage your sponsor license. What you are essentially doing is, on behalf of UKVI or border agency, you are taking responsibility for the employees that you are sponsoring. And in return for that, you have very strict obligations to UKVI to report to them. For example, if somebody doesn't show up on their first day of work, sponsored worker doesn't show up, or they've got a longer absence, or they change personal addresses, all of these things need to be reported back to the border agency. So you need to show the border agency that you have the right processes and procedures in place to essentially keep tabs on the individuals that you are sponsoring. And in that regard, it's highly likely that you will get an audit from UKVI, so a compliance visit, either when you're making the application form or at a later date. They can come unannounced, they couldn't come announced. We have noticed that compliance visits haven't been happening as regularly because of Corona, but I think they will, you know, don't get me wrong, they'll probably have a very long list of people they intend to visit once they are able to do so. So it's important that, you know, you don't underestimate this process. There are very strict obligations to UKVI once you have your system in place. But having said that, putting all the costs aside and the management time, you cannot employ non-UK workers under the new system without a sponsor license. So that's why many clients are looking at this as an option, because otherwise you may not be able to manage with the settled workforce, and you may need the license to recruit from overseas. Okay, if we can just move on, please. I said earlier that we'd touch briefly on right to work checks, and I think, you know, it's important that we don't overlook this obligation, especially at the moment, given everything else that we've got to deal with. So just to remind you all that you need to carry out pre-employment checks, so that you have a defence if you are found to be employing an illegal worker. So it's all about building up that statutory defence, carrying out the checks you need to carry out, so that then if the border agency do come knocking on your door, you've got all the necessary paperwork or e-files in place to show that you've done what you need to do, even if you are then found to be employing an illegal worker. Now, in terms of your EU workers, your checks shouldn't be changing until June 2021. So look at your list A and B again, just to remind yourself, but generally passport or national ID card should be fine for an EU worker. So that isn't changing. There will be new guidance coming out in terms of what you do after June. And you know, I'll be circulating updates as soon as I hear anything on that. So carry out your checks as normal. In terms of what's happening with COVID and how you should be carrying out your checks, there's a very useful guide that the government have published on their website. It's very easy to find. If you put COVID-19 right to work checks into Google, you'll see it. But this is the summary. So they're saying that checks must still be carried out, even in a pandemic. You've got to be carrying out right to work checks. The main change, though, is that, as is often the case now, these things can be done by video call. So what would happen is you would have your job applicant on the other end of a video call, and you would be able to see their face. You would ask them to hold up their original right to work document, so whatever it is that they are able to provide from list A and list B, and in front of your screen you would have a scanned version of their original document. You would then record that an adjusted check has been made, so you'd put the date, you'd say that an adjusted check was carried out, it was done by video conferencing, and again the on the government's website, you'll see that they've got template wording that you can use for this. Now, importantly, this is the most important point, if you have carried out a video call adjusted check, you need to then carry out a retrospective check. And they say that this is within 8 weeks of the COVID-19 measures ending. Now, nobody knows when the COVID-19 measures have ended, but we expect that UKVI will inform us when they deem the measures to have ended, but it's certainly not that, you know, the measures are ending after each lockdown. We haven't yet seen an end to any measures. So once we get notification that the measures have ended, you will then need to carry out a retrospective check, which will mean meeting that individual face to face, I expect, although we haven't actually had specific guidance on that. If you're just working as normal and job applicants are coming in as normal, obviously make sure you're doing it before the first day of employment, but you then don't need to carry out an adjusted check if you've done a normal check. So that's, you know, that's the easier option if, as I say, employees are coming into work as normal. Okay, and if we could just move on, please. And this is my last slide. It's really just a very short checklist in terms of things that as HR managers or as business owners you need to be thinking about for Brexit, and particularly focusing on immigration. So the EU settlement scheme, I think we've got, I think 4.9 million people have applied, but there are still more people who have not applied for the EU settlement scheme who are eligible. I read an article the other day, it was from a care sector magazine, and I think it said 16% of care workers are not UK citizens, so have come from outside of the UK, and 1 in 7 of them have not even heard of the EU settlement scheme. So there is still a huge proportion of our workforce, particularly in certain sectors, that are unaware of the EU settlement scheme. And it's such an easy process. It's a 30-minute application form on their phone, especially if they've got a national ID, and if they've got a national ID number, then it's very, very easy to prove their residency. So what I would say with your European workers is try not to single them out, because again, you run the risk of race discrimination, but make sure that there's posters that you can put from the government have published really useful posters or leaflets that you could leave around the workplace, or that you could email to everybody in your workforce, or put it on the intranet, where it's basically inviting people to apply for the EU settlement scheme. But also if they may have problems in applying. So I think we take for granted that, we've got Wi-Fi at home and we've got the internet, we've got the devices to be able to do these things. But some individuals who are eligible for the EU settlement scheme don't have access to those resources. So again, as an employer, can you go above and beyond to help your staff? Because it's going to be a lot easier to help them now than after the 30th of June, once the scheme's ended, if they then haven't made their application. As I've already said, continue with your right to work checks and diarise checks for May or June. So the process will undoubtedly change around June time, when we see the ending or the closing of the EU settlement scheme. We will get more guidance, but just make sure that, as I said, in the meantime, you're doing your checks as normal, and that you're then, you're ready and awaiting for further guidance in terms of what you need to do after June 2021. Consider the option of a sponsor licence. If you need medium and highly skilled workers from Europe that you have previously, come to rely upon, or you think you may need them in the future, then the sponsor licence is definitely the only way that you are going to be able to do that in the future. As I say, it's not for every employer, because it will not help you with the lower skilled workers. But there's certainly, I'm seeing many clients coming for help with sponsor licence applications. So there's definitely a demand for skilled workers from Europe that we're not being able to get from the settled workforce in the UK. With that in mind, I've said there, revisit your recruitment strategies and models, especially if you're impacted heavily by the inability to recruit lower skilled workers from the EU. You may need to look at how you are focusing in your recruitment strategy. So is there a way that you can attract more of the settled workforce for the jobs that you are advertising? Can you do term time only contracts, for example, or school hour contracts that then mean that people who perhaps wouldn't have applied for a role with your organisation are going to apply because it suits their work-life balance more. So have a think about that in terms of outside the box. You know, the government, the reason they did what they did was to reduce overall net migration. They appreciate there will be a shortage of workers to do certain roles, and they've done that. You know, they've not hidden from that fact, but they've said things like you need to increase automation, or you need to decrease your reliance on a workforce, you know, by increasing business efficiencies. So you're going to have to think about different ways in which, as I said, you can get the jobs done that were otherwise done by EU workers. A very final point: check your offer letters and contracts. And I would say this at the end of any immigration session, not just a Brexit one. You know, make sure that your offer letters are conditional upon the individual having the right to work in the UK, and that if for any reason they lose the right to work, that their employment would end. It's standard stuff, and obviously if you're a HR3 client, it's the things that we would check for you anyway. But just, it's worth having a look at them every now and then, just to make sure that they say what you need them to say. Okay, that's me done on Brexit.
Brilliant, thanks, Angela. We all get to stare at that delightful picture of me at the moment, which I'm going to dwell on a little bit longer than everybody else did. Just give you a bit of an intro to me first of all. A timely reminder of what life was like when haircuts were legally permitted. Responsible for that now for the past 12 months myself, which is why we're in the position that we're in. So good morning. I'm Chris Walker, Head of Health and Safety at Napthens H&S, and I lead our team of health and safety consultants. So for the team, we work with a variety of clients on a range of health and safety services. So our main aim is to help our clients evaluate their compliance with relevant health and safety legislation, provide them guidance and a steer on how to comply, and work with them to develop and implement their effective health and safety management systems. To put it into really simple terms, which helps, ultimately our objective is to make sure you know what you need to do from a health and safety point of view. We tell you whether what you're doing is good enough, and where there are gaps, where there are issues, we can assist you in fixing them, or we can do it for you in certain circumstances. What am I here for today? To give you a bit of an update and an overview of the state of the nation from a health and safety point of view. I'll try not to make it all doom and gloom, as there's plenty of that around the moment, but there is a little doom and gloom involved in the stats. So we'll have a look at how well we're doing as a nation managing health and safety, and give you an indication of what might have an impact on you as an organisation in 2021. And I've always wanted to say this, so next slide, please. Fantastic. So the session, we'll start with a quick look back at 2020, the headlines, the latest stats from the Health and Safety Executive on workplace accidents, injuries and ill health, as well as the enforcement action and outcomes prosecutions that are affecting organisations for health and safety breaches. We'll touch on the headlines with regard to occupational COVID-19 cases, and look forward to the key health and safety challenges which we'll face in 2021. There are going to be many overlaps between the challenges we faced in 2020 and those certainly that face us as organisations within the first 6 months of 2021. We'll touch on the Brexit impact on health and safety legislation, and the key legal changes and areas of HSE focus in the coming months. If you can just have the next slide, please. So to start off, we'll begin with a look at the key figures from the HSE for the last reporting period on workplace health and workplace injury. For anybody who isn't already aware, the HSE, who we'll refer to quite often through the presentation, are the Health and Safety Executive, and they are Britain's national regulator for workplace health and safety. Their key aim is to prevent workplace death, injury and ill health. And as part of their role as the UK's regulator, and to inform their future enforcement and engagement priorities, the HSE review and publish annual data on number and types of occurrences of workplace injury and ill health affecting sectors in the UK. So the stats we're looking at right now are from the latest reporting period, 2019-20. And the key headline that, as I look at it, is in the top left-hand corner, I think will be the same for you, is the 111 fatal injuries to workers in the course of their occupation in 2019-20, which is, I'm sure everybody would agree, 111 too many, but does represent a significant drop from recent figures. 149 workplace fatalities were reported in 2018-19. And when I stood at this session this time last year, I was talking about how the fact that that rate has been broadly flat for a fairly long time. We were reporting numbers of 135 to 149 over a period of 3 or 4 years, and not a lot was happening with that total number of workplace fatalities in the period. So what we can say this year is we've seen a reduction in the total numbers of fatal injuries. But what the HSE are telling us alongside these statistics is it is as yet unclear what impact the pandemic had on the last quarter of the reporting period. So certainly some economic impact in the high risk sectors in February and March 2020 may have reduced the total count of fatal injuries. How that number will compare in the next reporting period will be really interesting to see, as obviously output, productivity, economic activity overall has decreased substantially. Not necessarily in the higher risk sectors and the areas where the fatalities tend to happen. So it'll be interesting to see what those fatal injury incident rates look like at this time next year. The 2019-20 figure of 111 gives us the lowest ever recorded rate since the stats were measured in this way, at 0.34 workplace fatalities per 100,000 workers. So at the moment, we can say this is we're in an improving position, as long as this isn't a falsely altered result based on COVID alone. The most common causes of work-related fatalities consistently in recent years have been falls from height. And as you can see from the graph in the bottom left-hand corner, that continues to be the case in the latest figures. And from the graph in the top right-hand corner, we can see that construction and agriculture continue to be the sectors that have the most occurrences of work-related fatalities. The waste and recycling sector, although a low number, does have a much higher incidence rate than that which occurs in construction. And broadly speaking, we perform better in terms of fatal injury rates than comparable countries within Europe. If I could have the next slide, please. Fantastic. So non-fatal workplace accidents. First up, estimates of around about 0.7 million non-fatal injuries in 1920. But the key figure I really want to look at is the Riddle numbers. And the Riddle numbers on non-fatal injuries in the workplace. If you're not familiar with Riddle already, Riddle stands for the Reporting of Injuries, Diseases and Dangerous Occurrences Regulations, which ultimately is the bit of law that requires employers and other duty holders to tell the authorities when incidents of a specified nature and occurrences of a specified nature occur that affect or are in connection with their work activities or premises. So the non-fatal injuries reported to Riddle by employers, we're looking at a total of 65,427 in this reporting period. So that's over 65,000 reports of injuries to employers as a result of workplace accidents. Generally speaking, we're on a downward trend, so that number reduces year on year and has done consistently and continues to do so into this set of figures. However, when you think about what type of injuries and incidents require a Riddle report, 65,000 starts to feel like a much bigger number. When we think of the Riddle reportable injuries, we're talking about situations in which either, for the most part, an employee has had an accident in the workplace and that's resulted in 7 days or more of incapacitation, so inability to complete their normal duties in the workplace as a result of that injury, or what are termed specified injuries under Riddle, which are things as severe as fractures, amputations, serious burns, in certain situations asphyxiation, loss of sight, loss of vision, scalping, to name but a few. So while 65,000 does not sound an enormous number relative to the amount of people that work in the UK across its many sectors, that's 65,000 extremely serious injuries in many occasions. When you look then at where these incidents happen or why these incidents happen, slips, trips and falls on the same level account for 29% of those 65,000 serious injuries. And so often those slips, trips or falls are avoidable with simple control measures, simple maintenance routines, simple inspection procedures. And the question I would ask everyone is, are those risks, are those simple, what seem like low-level risks identified and adequately controlled in your work area? Solutions to slip, trip or fall incidents are often the cheapest, quickest and most effective to implement within your organisation. And if we as a nation could start to work on that 29% of slip, trip or fall incidents and reduce the amount of serious accidents we're having, overall that's going to have a really positive impact. Just touch on a bit of prosecution news with regard to slips, trips and falls. One of the most significant prosecutions that reached conclusion in 2020 was of Tesco's, who were fined £733,000 when a member of public slipped in an aisle in one of their stores. The member of public was 91 years old, otherwise fit and well until that point that he popped into Tesco's for his milk. And unfortunately, due to poor maintenance and lack of inspection and adequate regimes to keep control of their refrigeration units, a leak had occurred within the aisle of the store. The gentleman slipped over and broke his hip. So a really simple, avoidable situation, resulting in a slip, trip or fall, injuring a member of the public. Obviously having significant impact on that individual, but also costing Tesco's the best part of £750,000 in penalties alone. If we could have the next slide, please. Fantastic. On the work-related ill health front, I'm always keen to stress, almost on an annual basis until it gets better, that this is something that we need to do more with. Work-related injury and work-related fatality are long-term on a downward trend, which is excellent. The focus on safety in the workplace grows year on year. The initiatives, the drives from organisations, industry sectors, particularly the likes of the construction sector, who've made massive strides in recent times to reduce the amount of fatal injuries and fatal accidents. But we're not doing so good when it comes to management of work-related health. And I'm always keen to remind everybody, it is the Health and Safety at Work Act, not just the Safety at Work Act. We need to think about workplace health as well as workplace safety. And we can see that long-term trends in recent times are fairly plateaued when it comes to the work-related ill health per 100,000 workers. Of particular concern is the increase in stress, depression or anxiety situation, resulting in the majority of work-related loss or working time lost as a result of ill health in 2019-20. And also really keen to stress, this is pre-COVID. This is pre when the stress, depression and anxiety potential ramped up for many, many organisations. So again, it will be really key to see how COVID has that long-term impact on the stress, depression and anxiety figures. Key stat really there, again, I think is vital, is those 32.5 million lost working days due to work-related ill health and the 13,000 deaths that continue to occur each year, estimated to be linked with past exposures at work, things like chemicals and dust. One of the key areas of focus in recent times, outside of COVID-secure workplaces, for the Health and Safety Executive has been dust management and control of hazardous substances in the workplace, with a real focus on things like silica dust in the construction sector to try and reduce those numbers long term and the amount of individuals that are affected. If we could have the next slide, please. Excellent. So just a quick touch on occupational COVID-19 cases reported under Riddle. Now, this is not delivered with the intent to send everybody away panicking, thinking, oh my goodness, do I need to report COVID cases as a riddle? The Health and Safety Executive have given clear guidance on this, and they've given us clear guidance on the limited scenarios in which cases of COVID-19 and deaths arising from COVID-19 would actually be reportable under riddle. So for the most part, in most sectors, in most scenarios, COVID-19 cases and deaths from COVID-19 cases are unlikely to be reportable. Reporting should only be related to cases of COVID or deaths from COVID where it's an actual direct result of the work and the type of work that's being carried out. The Riddle regulations require that any disease or death as a result of contact with a biological agent, in this case the coronavirus, would be reportable under Riddle. But they've given us some clear guidance on where this does and doesn't apply. And the HSE tell us that if a worker is diagnosed as having COVID-19, there must be reasonable evidence to support the fact that this case of COVID-19 is due to occupational exposure. If that is the case, employers are required to report under Riddle. So the HSE tells us a lot more about what a reasonable evidence means in terms of occupational exposure. And we're talking about specific instances of scenarios where work requires, for example, an employee to actually directly work with a sufferer of COVID-19, somebody who is currently tested positive and has the condition, such as those working in COVID wards in hospitals, as an example. Work with the general public, for example, is excluded as opposed to those working with known infected persons. So the HSE tell us that it's not sufficient evidence to indicate a COVID-19 diagnosis is attributable to occupational exposure just because somebody works with members of the public. If they were working with known infected persons, that would be a completely different scenario. So remember, reporting is only necessary in instances where there are specific identifiable events and instances and exposures to COVID as a result of the occupational activity. The HSE asks us to question things like, is it more likely than not that the work was the source of the exposure? And stress particularly that at the moment, with COVID so prevalent in the general population, it's going to be very difficult to identify unless you're in specified roles and carrying out specified activities that the exposure is going to be linked to work, or you're going to be able to sort of make that reasonable evidential link of exposure to work in the general population. The HSE tells us that employers are not expected to conduct extensive inquiries into the source of a COVID case in the workplace and to base the judgment of whether or not it's work or not work related based on the information available at the time of the report, and stress that it's important not to submit Riddle reports on a precautionary basis. Just looking at the numbers, you won't be surprised that the majority of the Riddle cases, based on all the guidance I've just outlined for you, the majority of the 21,600 cases that have been reported by Riddle since April 2020 have been attributed to the health and social work sectors, so hospitals, care homes, and other social work sectors where regularly employees have been exposed in the course of their work to people with active cases of COVID. We're currently on the estimate of around about 65% of all the reports being health and social care related, and it's thought that this number is actually much higher due to many of them being miscategorized at the point of report. And at this point, we have a total of 254 death notifications. So where an organisation has reported to the HSE that a death has occurred due to COVID-19 and that COVID-19 case was linked to an occupational exposure. Since September, case numbers generally have been on the up and occupational notifications have increased, with more than sort of 60% coming since the end of September. We could have the next slide, please. So we have the Health and Safety Executive there to advise, engage with us and enforce against us when we get it wrong. Since 2015, there's been a substantial increase in the amount of penalties overall issued out to businesses as a result of new sentencing guidelines that came in back then. However, what we can see at the moment is that the total amount of prosecutions at £35.8 million for health and safety offences is much lower than in the preceding 2 years. And this is mainly due to the apparent number or reduced number of cases that actually reach prosecution in total. So the thought is that the value of the average health and safety executive penalty has maintained its nice high level, and the success rate at prosecution has maintained its reasonably high level, but less cases are being prosecuted in total. Obviously, these numbers predate COVID and the potential for COVID enforcement notices for failure to properly assess and manage the risks associated with COVID in the workplace. Although at last count, there weren't significant numbers, certainly, that had made it to prosecution from the Health and Safety Executive for COVID secure breaches. If we could have the next slide, please. So in terms of 2021 and looking forwards, it's impossible to look forwards without looking back again a little bit and considering how we're going to stay COVID secure and perhaps even more importantly for our businesses, COVID resilient in 2021. COVID secure guidance is still regularly being updated by the government. And how we manage our workplaces and our operations is still under increased scrutiny from the Health and Safety Executive and local authority spot checks. Our experience so far in managing these workplace inspections is that businesses are doing a good job and that wherever possible, the local authority and HSE are offering support, guidance and coaching rather than trying to beat organisations with a stick on the COVID measures. If you're operating at the moment in line with government guidance, if everyone's working from home that should be working from home or can be working from home, and you put COVID secure measures into your workplace, there's not probably a great deal to worry about from a HSE perspective. Although one thing I would stress is that regular employee training, induction, awareness, and sort of re-emphasising the importance of those control measures is key to ensuring that you keep the momentum and keep the virus under control within the workplace to avoid outbreak situations. If you haven't reviewed your COVID risk assessment since April last year, then I very strongly suggest that you do so. A lot has changed since then, not just in what the government tell us is a safe way of managing the virus in the workplace, but also the risk. There's a hell of a lot more of that virus about than there was when we first drafted our COVID risk assessments. We know a little bit more about the transmission. So if you've not reviewed your COVID-19 risk assessment since April last year, I suggest that's job number one once you're off this call today. Need to consider that ongoing impact on home workers as the scenario continues to unfold. What are we doing about home worker health and safety as this sort of the emergency period continues and workers are still in many cases not placed in ideal situations from a home working point of view? Are we engaging with them on mental health? Are we looking after their well-being, as well as considering the risks from displaced green equipment use and the ergonomics? Now that we're in a more prolonged situation, the risk of long-term health impacts from poor ergonomics associated with workstations is increasing. So we need to reconsider our organisation's approach to thinking about how we manage that home worker health and safety as it goes on. If I could have the next slide, please. A couple of key changes to run through with you. The good news on the Brexit front, although a couple of people I've spoken to have said it's bad news, is we're not ripping up the Health and Safety at Work Act. It still counts. And now that we've left the EU, I must remind everyone that all of the fundamental duties and responsibilities regarding management of health and safety in the workplace, management of everyone who might be affected by your activities, protecting your workers, protecting others, all of that still remains, Brexit or no Brexit. The Health and Safety at Work Act is still in place and all of its supplementary regulations still apply. In some industries, there are some things you need to be aware of. We've already left the EU, so preparing for these would have been beneficial. Certainly last year, if you're in the chemicals, explosives, or you're in the industry that places equipment or machinery on the domestic or EU markets. If you do, if any of those sectors do apply to you or you're in those areas, then certainly review the HSE guidance on those changes and do seek some support if you need it. I will touch very briefly on the Fire Safety Bill and the Regulatory Reform Order 2005. So in response to the tragic events of Grenfell Tower in 2017, obviously fire safety has been very high on the agenda of regulators and the government. And there are a range of measures proposed and progressed with a view to preventing any such similar event having such catastrophic consequences in the future. At the moment, meandering its way through the parliamentary process is the Fire Safety Bill. And the Fire Safety Bill will amend the Regulatory Reform Fire Safety Order 2005. That's the bit of legislation that tells you need to have a fire risk assessment, and you need to reduce the risk of fire within your workplace and the risk of the consequences of fire to your employees. The Fire Safety Bill will ensure that there's greater clarity on the duties and responsibilities of individuals associated with certain types of buildings and certain properties. It's really worth also being aware that a new building safety regulator has been created within the HSE, which will be responsible for implementing and policing the new regime for higher risk buildings. Alongside that, I think the key point to stress, without going into the technical detail of the Fire Safety Bill, is that fire safety is high on the agenda now, and it is the time to look at your own business and your own premises and ensure that you have the necessary fire risk assessments in place, but also that you've fully implemented fire safety management throughout your organisation. If we can have the next slide, please. Fantastic. So I just wanted to touch on exciting developments from the world of Napthens Health and Safety to finish up. 2021 is going to be an exciting year for us and hopefully for our many clients as well. Napthens Health and Safety have always been there to guide clients through the journey to compliance, to help them understand obligations and compliance status, and to get access to that competent health and safety support and advice. But now we have an online portal to help simplify your health and safety management systems. So new developments in technology complement our health and safety advisory services and will be available to our clients throughout the year. We can have the next slide, please. So the Napthens People Portal, as Chris Boyle picked up on right at the very beginning from an employment law perspective, the key purpose is to take the pain and paperwork out of your health and safety management system. So we work with our clients on developing and implementing documents associated with their health and safety management system. The Napthens People Portal gives them the power to manage that simply, effectively, and efficiently. So the system, you see in front of you, the risk assessment module, the system provides for simplified, standardized processes for creating, storing, issuing, and recording acknowledgement of health and safety documents. It puts you in control. You have dashboard reporting. If we can flick onto the next slide. So you see here we have the incident manager module. You can see the status of any ongoing incidents, accidents, reports and processes within your organization. If you can just go on to the last slide for me. And here we have all of your health and safety data presented in one place on fully configurable dashboards based on the information that you want to know about how well your health and safety management system is performing. So if Napthens Health and Safety are advising you, telling you what your gaps are, and helping you close those gaps, you can see progress against that action plan, against that compliance status, all presented in the Napthens People Portal. And ultimately, it provides a platform for collaboration and a collaborative relationship between our consultants and businesses, so that we can ultimately work together and partner much better in solving your health and safety headaches. And that brings me to the end.
Okay, thanks, Chris, and thanks to Chris King, Roxanne, and Angela as well for that presentation. There are a few questions in the chat box, which I'm just going to, the majority for Angela, which I'm sure she'll enjoy. If we can, the first one is, how can we go about checking those statuses with employees without potentially offending?
Okay, yeah, in terms of your right to work checks. So
yeah,
what I would say on that is, don't carry out unnecessary checks. So at the moment, if we're talking specifically about EU workers there is no requirement to carry out retrospective checks at the moment on your EU workers. So if you were to go and try and you know, pick them out to say, we're not sure if you've got the right to work, that's something that is not required of you in terms of the UKVI at the moment, and that potentially would lead to a discrimination claim. So don't do something that you don't need to do. Don't carry out retrospective checks. Nothing is going to change on that until June. we will have more guidance we're told in May, June time, so that then that will give us some justification for going out and making those checks when we need to, which will be from the 1st of July onwards. So what I would say is, in terms of not offending or not running the risk of a discrimination claim, don't carry out a check that you don't need to. You don't need to do any checks on your current employees at the moment, only for your new starters, which you would be doing anyway. And then let's see what happens in terms of government guidance in May, June time as to what they expect you to do in terms of document checking going forward for EU workers.
Okay. And then second question for Peter, if we use an agency to get hospitality staff, many are non-UK, is it down to the agency to check?
Okay, so if the agency are the employer, then it's down to them to check. So it always follows whoever is the employer has the duty to carry out the check. And what I would say is, if the agency is employing these individuals, you shouldn't be carrying out the checks, because that can blur the line in terms of employee status, who is employing those individuals. If you're carrying out right to work checks, that can be a pointer to them being an employee of yours rather than the employee of the agency. So yeah, firmly sits with them if they are the employer, and then it should be a matter of your commercial terms with the agency, you know, to make sure that they're doing the checks that they need to do. Because let's be honest, you don't really want, regardless of who is employing that individual, you don't really want the border agency to carry out a spot check at your site and find illegal workers, because the press won't care who employs them. They'll just say that there were illegal workers found. So make sure that your commercial terms are tight and that the agency will be carrying out those checks if they're the employer.
Okey-doke. And then what would happen if an EU person employed didn't want to, or refused, or just said they aren't telling us if they apply?
Yeah, and that's the trickiest question that I'm coming across at the moment. As I said, as things stand, there is no requirement for them to give you anything different. So you shouldn't even be asking for additional documents. You know, yes, they can volunteer that information to you, but you shouldn't be making it a requirement. So there shouldn't be that level of confrontation yet. We'll need to revisit it from the 1st of July onwards, because I think there will be confrontation. There will be EU people who have lived here for 30 years who say, you know, I shouldn't have to prove my status. And I think the government is going to have to address that and give employers guidance on what they need to do in those situations. So, you know, let's cross that bridge when we come to it, but hopefully we'll get more guidance in the meantime.
Okay. And then, do you need a sponsor license where an applicant is on the shortage occupational list / or has a PhD?
Yeah, so you still need a license. It's still the skilled worker category. It's just that if they have a PhD or it's on the shortage occupation list, you can potentially pay them a lower salary than they would if the role was not on the list or they didn't have the PhD. So yeah, it's still a sponsor license that you need in order to bring them into the UK.
Okay, great stuff. And then one for Chris Walker, I think, Health and Safety. Does a business have to report if there are more than one case of COVID in their place of work to the local health protection team?
Okay, yeah, thanks, Chris. No, is the answer. Not in the first instance. The COVID secure guidance, first place to check is your sector-specific COVID secure guidance, and that will direct you towards the Public Health England action cards. So if you have a confirmed case associated with your workplace, check the Public Health England action card. Follow the early outbreak management plan within that action card. And if you're struggling having followed all of those actions, or considering a business closure for most sectors, that's where Public Health England will ask you to contact them for further advice on how to manage the outbreak. Originally, the guidance going back to the summer last year was if you had one or more cases to report that immediately to PHE, but that's been superseded by the action cards.
Good stuff. And then the final question is from Daniel Lord. So I'm not sure what the question is, Daniel. I don't know whether we can unmute you to ask it or not. Kane, can we? I don't know. But my question is regarding outbreak management. I'm not quite sure what the question is there. Can we unmute Daniel, Kane?
Yeah, just trying to.
If Daniel wants to ask it.
Daniel, you'll just need to unmute yourself if you'd like to ask your question.
Oh, sorry. It was Daniel Lord, Kane. I think you may have unmuted Daniel Staines.
Yeah, I've unmuted Daniel Lord as well.
Okay. All right. Well, perhaps if we can't ask the question now, perhaps we can answer it perhaps after the call. We've got some issues with that, but okay, that's all. I think that's all the questions that we've got.
Sorry, Chris, I think there was just one more that I can answer. It was just about basically getting a third party to carry out right to work checks on behalf of the company. And if we could recommend anyone, I wouldn't necessarily say I can recommend any particular company. I have heard of Yoti, which is the one that the individuals asked specifically about. All I would say is word of caution when it comes to outsourcing, that the book firmly stops with the employer. So yes, you can outsource right to work checks, and there's lots of companies, some more legitimate than others, that provide that sort of service, but it doesn't come without risk. So if you are going to do it, make sure it's a reputable company, but also make sure that you are regularly auditing and checking that what they're saying they're doing is what they are actually doing, because the border agency, as I say, they won't care if you've outsourced it or not. They will be coming to your door, knocking on your door in terms of whether or not you've got your statutory defence for document checking. Okay, good stuff. And we've now, thanks Daniel for the question. So Chris, I think this is possibly one for you. Or it could be one for me as well, I don't know. But my question is regarding COVID-19 outbreak management. Guidance states that individuals only need to isolate when contacted by test and trace following close contact with a positive COVID-19 case. Early outbreak management plan published by PHE states that close contacts must isolate for 10 days when identified by the company. Can you clear this up?
I can try. I think, first and foremost, the test and trace service, if they're contacted, then absolutely the duties they must isolate. You must not encourage them to come to work. With regards to PHE action cards, I'd have to revisit the action card that you're specifically referring to. But as I understand it, at my last read through, the action card only stated that those with a positive test had to isolate, and if you identified close contacts, you should advise them accordingly. I didn't note that it actually said they have to isolate for 10 days. So if you wanted to send over the specific action card you're looking at, I'd be more than happy to have a look at that for you.
Okay, we can perhaps pick that up after then. Thank you. Right, I think that's all the questions. So just final slide, please, Charlotte. Just wanted to update attendees on some of the things we've got coming up. So you've probably seen on the website, we send these out regularly. These are some of the events we've got coming up over the next few months. We do have Q&A sessions, which you may have seen we started doing for HR3 clients and retained clients. We held one yesterday on SARS with Rachel Atherton under the Data Protection Act. We've got another one coming up on the 9th of Feb on IR35 and one on the 19th of March on tribunal procedure. So these are specific Q&A sessions just for HR3 clients and retained clients as well. So we look forward to seeing you there. That's it. Again, many thanks to the speakers today, Chris King, Roxanne, Chris Walker and Angela. Thanks for everyone for attending, and then we hope to see you again soon at some of the events we've got, and of course we'll speak to you on a daily basis. See you soon. Thank you.
Bye.
Bye.
Bye.